Welcome to the Eating at a Meeting podcast. I'm your host, Tracy Stuckrath, dietary needs expert, certified meetings manager, certified food protection manager. I have searched the globe to find people and businesses who are creating safe, sustainable, and inclusive food and beverage experiences for their employees, guests, and communities. In each episode, you will find authentic conversations about how food and beverage impacts inclusion, sustainability, culture, community, health, and wellness. I know that sounds like a lot, but we're going to cover it all. Are you ready to feed engagement, nourish inclusion, and bolster your bottom line? If so, let's go.
Hi, everybody, and welcome to another episode of Eating at a Meeting. I'm your host, Tracy Stuckrath. I'm back in the home office today after being on vacation. And I'm so excited that today for the show, the July 26th is the 33rd anniversary of the Americans with Disabilities Act. And so that's what I wanted to cover today. And I'm so excited to bring in an attorney to talk to you about what the ADA is and how it does actually apply to food and beverage at meetings and events at universities, et cetera. So please help me welcome Laurel Francoeur. She's an attorney. And so hello, Laurel. How are you?
Hi. Thank you for having me.
You're welcome. I'm so excited. I mean, I finally met you in person last year at the FAIR conference, and you did a great presentation there. And I think it was about colleges. I think that was the one that you did. But anyways, I know you have been doing a lot of work around this. So can you tell people what kind of law that you practice and how long you've been doing the focus that you have?
I have a niche practice where I focus on food allergy issues. So what I do is I help people get accommodations at school. I help people who have been discriminated because of their food allergies. And I also help people who have had reactions at restaurants. I also do a lot of advocacy. I go around the country speaking about food allergy and the law. I've written some books. So that's basically my focus is almost exclusively on food allergy law.
And you got into it because of your son, is that correct?
Yes, in 2001, when my son was 1 year old, he had an anaphylactic reaction to peanuts. And from then he was diagnosed with peanuts, tree nuts, eggs, soy, sesame, shellfish.
Wow.
And so back in 2001, there weren't any resources. The internet was in its infancy. So he went to preschool and then went to kindergarten, had a life-threatening reaction at kindergarten. The school didn't know how to react, and he almost died. And then I realized there needs to be education about this. Things need to change. So I decided I would stop practicing full-time and devote myself to food allergy advocacy. And one of the things I did is I got a bill passed in Massachusetts to allow EpiPens in the classroom in all of Massachusetts schools. Because one of the issues was when he had the reaction, the nurse's office was on one end of the building where his EpiPen was, and he was on the other end of the building.
Wow.
And then that just sort of evolved.
Yeah. And now every state has laws about having EpiPens, stock EpiPens on campus, but it doesn't necessarily mean they're in a classroom.
Can you believe Massachusetts is the one holdout? We do not have a stock Epi mandatory in Massachusetts.
Wow. But you do have laws about allergen labeling or communicating your allergens in restaurants.
Yes. What's interesting is Massachusetts was the first to pass a bill about food allergies in restaurants. We're also the first to come up with guidelines about how to handle food allergies in school and other situations. But we don't have stock epinephrine laws. A lot of schools have them anyway. What they do is they work with their physician and they get a standing order to have extra epinephrine. But we don't have an actual law that requires it.
Wow. Yeah. That's crazy. Yeah, Lynn Wellish is here. She said, thanks for having a passion that changes the way we meet. You're welcome, Lynn. Thank you for being here.
Thank you.
Well, and I remember going to a convention at the convention center. Makes sense. And it was a convention for 4,000 people, and they had big 24 by 32 big posters labeling or listing what was on the buffets. And at the very bottom of it, it says, please let us know in advance of being served if you have any allergens. And I'm like, it kind of makes me laugh and annoyed at the same time because the food is already displayed, right? So there's not really much that they can do at that point I mean, but by law, they have to put that on that sign, correct?
Yeah, and the way that came about is it started with the Massachusetts law. And the original law that they proposed was going to say that all restaurants had to label all ingredients of everything they served.
Mm-hmm.
And I don't know if Ming Tsai, but he has what he calls the allergen book that lists all of his ingredients. But there was pushback from the Massachusetts Restaurant Association and the National Restaurant Association saying we don't want to have to disclose proprietary recipes and so forth. So the compromise was, we'll say you have to ask your server, and then your server will have to tell you whether the food has an allergen in it or not. So that was sort of done as a compromise solution. And now that's why you see it on all of the menus, at least in Massachusetts and in several other states who have the same law.
Yeah, exactly. Okay, so talking through that as well, I mean, that's just as important. But today, at the anniversary of the Americans with Disabilities Act, can you explain what and that was created in 1990? And then I want to jump to the addendum that was done, the amendment that was done in 2008.
So very briefly, I'll give you a very brief history. In 1973, we had the Rehabilitation Act, 504, people are probably familiar with. And that applies to places that get federal funding. And at the time it was passed, they were having a hard time getting the regulations passed with it. So a group of disability rights advocates, including Judy Newman, who is famous in this field, started basically a campaign where they did sit-ins, they did marches, and they pushed to expand that into other areas besides just federally funded programs. And they worked for so many years and then finally got the ADA passed in 1990. And so the ADA has three parts. It applies to employers, it applies to state agencies, and it applies to places of public accommodation. So it's not just the federal funding as 504 was, it's expanded it. And it says that anybody who has a limitation that substantially limits of a major life activity is considered disabled. Unfortunately, they still use the word disabled in the statute, and is entitled to protection. And then there are certain regulations and categories of how it's applied.
And protection mean? When we say that?
Reasonable accommodations. So you have to be accommodated so that you can fully enjoy the benefits and participation in the programs that are being offered. So for instance, if it's a theater, you have to be able to fully participate in being able to watch the movie and so forth.
Okay.
And that recently is translated into closed captioning for hard of hearing people. But there are some exceptions. So if a company can say, this is going to be a really hard burden for me, it costs a lot of money, or if it's going to change fundamentally the way I do things, they may not have to make accommodations. So there's a little wiggle room. But you basically start with the fact that somebody who is disabled is entitled to reasonable accommodations.
And that reasonable depends on the situation.
Exactly.
Right. Yeah.
Situation by situation.
Right. And I think the story that I use, I'm like, if you're in a hotel in downtown Boston, we're just going to use Boston, or you're in the middle of the desert and you're having an event and you show up and you say, hey, I've got a milk allergy. The hotel in Boston probably can accommodate, there's a reasonable accommodation to be able to provide that. But in the middle of the desert, if you didn't tell them in advance, that's going to be kind of hard. Is that right? Yeah.
Yeah. It really varies on the circumstances. Yeah. And also, for instance, if it's like national chains, for instance, may be required to do more than a mom and pop shop would.
Right.
Because they have a wider reach, more money and so forth. But as you said, it really depends situation by situation.
Now, can we talk about the places of public accommodation? Because just before we got on the show, you mentioned private clubs and then conventions. And then I was like, what about convention centers and hotels? Can you describe what a place of public accommodation is?
So it's a place that offers services to the public. So anything that advertises or offers products to the general public. So and the ADA lists specific things, but it's even broader than that. So they list things like churches, hotels, restaurants, theaters, daycare centers, and now that's even been expanded to websites. So there are a few cases that say a website is a place of public accommodation too.
Yeah, there's lots of, I've got friends that are advocating for the accessibility of websites. And I know there's attorneys out there that are suing different properties or different entities because of their accessibility of those. So when the ADA, so I mentioned just a second ago that that it was amended in 2008. Can you talk about what that amendment is and what it made different between the original and the new one?
Sure. So courts were taking the ADA and interpreting it very narrowly and excluding people who Congress thought should be included for protections. So in 2008, they passed the Amendments Act. And what that did is it expanded the definition of disability, so to include things like eating and breathing. But it also said that things that are episodic in nature are to be considered disabilities when they're active. And you can't look at mitigating measures. So for instance, with a food allergy, a person is not having anaphylaxis 24 hours a day. It's an episodic thing. So you can't say because you only have a reaction when you eat the food, you're not disabled the rest of the time. So
wow, okay.
You have to consider things that are episodic in nature. And then you can't consider mitigating measures. So for instance, there were some cases about asthma where people said, well, as soon as you take your inhaler, you're no longer having a problem, so now you're not disabled. So as long as you have your inhaler or you have your cane, whatever, you're not disabled. And so the changes said you can't look at that. You can't look at any mitigating. You can't look at the fact that somebody has an EpiPen and say, okay, they're not disabled because the EpiPen will cure them. So those are
we know that doesn't happen.
Yeah, but those are big changes, and it really helped with food allergy, particular.
Okay, before we go into my next question, I just want to say in here that Facebook user said one of her clients is AHEAD, the Association of Higher Education and Disability, saw lots of references to Judy Newman. Said the conference that they just did was great. So Judy passed away, right?
Passed, yeah. She has a great book, Being Human. She's also featured in the movie Crip Camp, which is about the whole history of the ADA and her advocacy. Yeah, she's an incredible woman, or was an incredible woman.
I still need to see it. I tried to see it at Sundance, and you could not get in. So I still need to watch it. You can't say that because somebody's got an EpiPen that they're not disabled now. So how does that play into? I mean, we've got a lot of listeners that Lennon and that other Facebook user are meeting planners. So how does that play into what we do when, say, you or I are registering for that AHEAD conference, and one, they ask us about food if we have any dietary restrictions, and two, that food, the meals come with our registration fee. So it's $500 to attend, and we're going to get fed 4 times or 5 times, whatever, during that time frame. How does that impact us as meeting planners, as well as the venues and caterers that we use to work with?
So if you have a private club and you just serve food to your members, you don't have to abide by the ADA. But if you're a club or some kind of organization that serves the public or invites non-members in to have a meal that they pay for, then you're treated like a public accommodation and you have to accommodate.
So if I create an event and then I'm going to host it at XYZ Convention Center and it's open to members and non-members of my association, then I have to provide accommodation.
You have to provide accommodations. But the question is that what accommodations do you have to provide? And that's where things get a little tricky, because if you don't normally make menu changes for people, you may not have to change your menu to accommodate someone with food allergies. So,
but as we can see that, and just from experience in the last 10 years, a lot of places are making those changes and offering options. And so because of precedent or duty of care, what they've done in the past can show that, hey, you've done this in the past, why not do it now, right?
Right. It can so basically their argument is it's too hard to do it. But if you've done it in the past, then obviously it's not too hard for you to do it. It's something that you can do. So then you'll be required to do more and accommodate, meaning changing your menu.
And this is Inga who posted the last statement and this one. She said she had an extensive list and Levy worked with us, especially on labeling. Oh, that's great to know. Yay. Levy Restaurant Group does a lot of in-house catering at convention centers. So It reminds me of a case from a couple of years ago, Williamsburg, and this is going to tie into an Instagram post that I saw too this morning. I don't know if I can pull that up, but the Natasha Foundation in the UK posted a sign that said, if you have a food allergy, please speak to a member of the staff. And then in different colors says, but if it's a serious allergy, we can't accommodate you. And then with the hashtag discrimination. How does that, and then I'm going to tie it into that Williamsburg case where this little boy came to eat lunch at the school field trip. He paid the full fare to participate, but when he brought his own food out, they tried to kick him out or said, you have 3 options. You eat our food the way we make it, you leave, or you don't eat. You sit here and eat. And he ended up winning it after appeal, but one, that he had a food allergy, and 2, that he had the right to bring in his own food because they found that they had done it in the past. I just threw a whole bunch of stuff in that one paragraph.
Yeah, so the court held that it could be a reasonable accommodation to allow somebody to bring in outside food.
Okay.
And actually, I just found a case that DOJ mitigated or had a mitigation about in Kentucky where somebody with diabetes wanted to bring outside food into a theater. And the theater agreed during mediation that they would do that and post a sign saying, if you have disabilities, you'll be allowed to bring your own food. So
wow.
Yeah. So I think things are changing on that in that realm in terms of bringing in food. And there's also a Chuck E. Cheese case several years back where somebody wanted to bring in a birthday cake that was allergen-free to Chuck E. Cheese, and they wouldn't let them. And the court said, no, that could be a reasonable accommodation to allow them to bring their own food.
Right. Okay, so, all right, that reminds me of a whole nother thing that my friend, restaurant owner, and because a lot of people in restaurants don't allow outside food to come in because of food safety practices. And a friend of mine allowed a birthday cake to come into the restaurant. They bought it, and on the label it says made in a facility that also processes peanuts. And somebody on their team had a peanut allergy, and the owner of the restaurant did all the cooking. This person passed away from eating at this dinner, but it was from the cake. But there's a lot of sticky situations in that.
Yeah. And a lot of restaurants do look to the food code. The food code really is talking about food that you have prepared.
Okay.
So, and in fact, when the earlier decision in the Williamsburg case, one of the judges who was later overruled made the argument about a salmonella or something like that. Another, completely, you can't bring in food that has salmonella in it. Well,
who's going to choose that?
But that was overruled later in the appeals court. But
right.
But there is this fear that maybe now you're bringing in something to the restaurant that the restaurant can't control.
Right.
And maybe it does have something that's harmful to other people. So I think the way, again, you look at it a case-by-case basis, and the court doesn't say you have to allow food in. It just says that you may have to in certain circumstances.
Right. And there's people like Inga said, we have an extensive list of people with food allergies. And I've gotten attendees whose list is a whole page long themselves. And the chef will say, okay, what do you want to eat? What can I make you? What do you eat at home? Things like that. Or provides them a microwave or something of the sort, to do that. But I think it is a case-by-case situation. Now, I want to clarify too, under the ADA, what types of dietary needs would fall under it? You've mentioned diabetes and we've talked food allergies, but does vegan, vegetarian, or religious-based dietary needs fall under the ADA?
No, it has to be a disability. So it has to be a condition that impacts a major life activity, like eating or breathing. It can't be a choice or preference.
Okay.
That's not covered. This is for people with disabilities. So with food allergies, they say a severe food allergy. The OJ calls it my argument is that every food allergy is severe, but celiac has been held to be a disability because that affects, again, your immune system, and it affects your gut and affects your ability to eat safely.
Yeah, and you could say that about food allergies again. And I guess that argument also comes with a lot of people who are getting the tested are saying, hey, this is an intolerance versus an IEG food allergy, right? But do you have to prove that?
Make the argument that the intolerance affects you significantly, then it would be covered.
Okay.
So, for instance, maybe lactose intolerance. I mean, again, maybe it's not life-threatening, but again, that's, again, case by case. So, for instance, in 1999, before the amendment was passed to the ADA, there was a leading case called Land versus Baptist, and it was involving a child care center in Arkansas. And the court held that a food allergy was not a disability. It really didn't have a major impact on this child because they couldn't eat peanuts, but they could eat everything else. So that was basically overruled by the 2008 amendments. Because but some courts still go back to that case and cite it and say food allergies are not a disability.
Wow.
Oh, yeah.
Even 15 years after the amendment.
Yes. Yeah. So if you're a plaintiff, for instance, suing somebody, the burden is on you to show that your food allergy qualifies as a disability. It's not going to be something that's automatically assumed or taken for granted. You still have the burden of proof, and some courts are easier to prove it than others. It's getting better. There are more and more cases that we're bringing that are making it a lot easier than it was. But just to be aware, there are some courts that still stick to the old.
Well, there's some states that are still using the 1995 food code. So 28 years later, right? Okay, so and we've kind of covered this under already a little bit, but to provide a reasonable accommodation, what are some best practices that you see for a meeting, for a place of public accommodation, a convention center or hotel, food for guests?
Well, I think the big things would be so that people know what they're eating and what they're going to be exposed to. And also, obviously, allow people to bring their EpiPens, allow them to have their medication with them. The best thing is if you could talk personally to that person who has listed, say, on the form, okay, I have a food allergy, to talk to them and to say, how does it affect you? What do you need? What can I do? What do you normally eat that's okay? And sort of have an interactive conversation with the person. That, I think, is the best practice, because then you really know what to avoid. And also be aware of cross-contamination. So sometimes you might, in the way you prepare things, cross contact with allergens. So to be aware that if you have somebody with an allergy, you might want to segregate where you make their food.
Okay. All right. That's a really good point. Now, and I don't know why this just popped into my head, but it did. And somebody was saying at an event that the ADA is just the basic guideline, right? And it's there as the base level. Why not exceed it? Right? Why not take a step above and exceed it? But it's like, this is the law, the minimum law that you have to do. And do you have any guidance on that, on why it's better to go above and beyond?
Well, in fact, some states have their own civil rights laws that surpass the ADA, that do have more requirements. So states are allowed to impose more requirements, and a lot of states do. But I think it's just best practice. I mean, if you're, there was a Paul Antico, I don't know, Paul Antico, who did Allergy Eats. He did an analysis of how much money a business would lose if they didn't help people with food allergies. And it was an astonishing number. And so basically, in other words, if you can't serve, say, my son, then you're not just losing his business, you're losing my business, his aunt's business, his grandmother's business. So it compounds. So it really is in your best interest to do what you can to help people with food allergies and to make them feel included.
Very, very true. And it provides a better experience overall. It's universal design, right? And that, I think that was the intent of the ADA, was universal design. Is that correct?
Exactly. Yes. Again, so that people can equally enjoy the benefits, so that somebody is not sitting out in the rain, like in the Williamsburg case. Mm-hmm. Or one of the best places we ever ate was in Montreal at zero. So it was free, 08 it was called. It was free of all the 8 allergens, and not even in the restaurant. My son was in heaven. He could look at a menu and not have to parse it and say, well, can I eat this? Can I eat that? He said, Mom, I can even eat dessert. And he could never eat dessert at a restaurant. So he says, I don't even have to, ask. Everything is free of the top 8 allergens. So for him, that was wonderful. He could just have a meal and not worry and not have to figure out and do this calculation. What can I eat? What can't I eat? Unfortunately, they went out of business
Oh,
but
dang it. So, and was the food good?
Because it was very good. Yeah, it was very good.
And in May, during Celiac Disease and Food Allergy Awareness Month, I interviewed an innkeeper in Maryland, Eastern Shore, and the air or bed and breakfast is completely gluten-free because she's got celiac. And she said she has guests coming that aren't celiac because the food is so good.
Wow.
And I mean, and that's the kind of, I think, the same mentality. And like, if Mikey likes it, not the food allergic person, then why not? Right?
Yeah.
Yeah.
And I think what people don't understand with food allergies is the whole emotional component. So it's not just that you're going to have a reaction, you're going to have a life-threatening reaction. And the nervousness and the fear that goes along with that impacts people with food allergies just as much as the allergy itself. So again, sitting down in a restaurant and saying, am I going to be okay? That whole emotional side to it is part of the whole food allergy experience, unfortunately. And people have to understand that it's not just changing a meal here and there. It's making people feel comfortable and included.
Okay. Now, okay, and we were talking before the show started about a case that you have, and I saw another Instagram post this morning from a friend of mine who was talking about, well, it was actually talking about people who have food allergies, and we get frustrated by the servers who don't understand us and don't understand the severity of it. And so we become rude and defensive because we want to be able to eat here. But at the same time, I think some of that is triggered from staff who aren't trained or staff who consider it, oh, whatever, you're not going to die. Don't consider the severity of it. Can you talk about that a little bit?
Yes, so I currently have a case against Chipotle, which is usually known as a very allergen-friendly place. But this woman with a gluten allergy, not celiac, but an actual IgE allergy to gluten, went into a Chipotle and asked, oh, what can I eat? She'd eaten at Chipotle's 1,000 times before. She knew that they had gluten-free options, that there were only a few things that had gluten in them. But then she was basically told everything has gluten. And she said, well, can't you usually change your gloves? You have this procedure. No, we're not going to do it. They called the manager over, said, this is the gluten lady. And then basically the manager said, you have to leave. And
wow,
she had to leave the restaurant without being served. So I'm suing Chipotle on behalf of her for discrimination. So she's not asking again for Chipotle to change its menu. She's just asking that she be able to be served and to be treated with respect and not to be told you cannot eat here, leave.
Which is what a lot of people with food allergies have that problem right now. And there's a lot of that going on in the UK for sure. But now I'm curious because it's Chipotle. Are they franchised or is it all corporate owned restaurants?
I believe they're all corporate owned.
Okay. And that could play a big difference in what happens as well, correct?
Yeah.
Because a lot of hotels, I mean, I don't know how many hotels there are in the country, but, they maybe carry the XYZ name on it, right? The big brands that we know, but it's owned by you, but managed by me. And if I have that problem, who would I go to?
Well, I mean, if I were to sue, I would sue everybody. I'd sue everybody because everybody would be responsible.
Yeah. I mean, so even a franchise, the corporate name could be sued even if it's a franchise organization.
Yes, especially if you can show that the corporate entity has a lot of control over the franchisee. So they control the way things are made. Food has to be made a certain way. They have to use certain ingredients. Mm-hmm. So if the company has a lot of control over their franchisees, then they can be responsible.
Okay. Yeah, I don't necessarily know that the Marriotts of the world have control over what the hotels serve in their food and beverage or select on the food and beverage, but I don't know that for 100% sure. But yeah, that's interesting. Okay, so now I want to ask a question about there's meetings that are held for the general public, a food festival, right? Or there's meetings held for XYZ Association or ABC Corporation, an internal sales meeting. Does the ADA apply differently for if it's an employee of XYZ company versus, hey, this is a conference for the food allergy world? Food allergy eaters of the world, Does it apply differently if I'm paying a registration fee or not paying a registration fee as an employee?
Well, so under Title I of the ADA, employers who have 15 or more employees have to accommodate for the employee's food allergy or disabilities. Companies that have fewer than 15 employees do not, at least under the ADA. So the question would be then, is the company the employer, and are they accommodating an employee, or are they accommodating somebody who is not an employee, but maybe they're open to the public, and so they're a public venue, so now they're a public accommodation. So you really have to look at, again, it's an individual case-by-case decision.
And does somebody from the general public have more or less protection under the ADA versus an employee, considering it's over 15 employees?
No, I mean, they both have to make accommodations.
Okay.
Yeah.
Okay.
Yeah. Once you fall under ADA, you have to make a reasonable accommodation.
Okay. And I don't know why this just popped into my head too, but all these questions are doing that. So when you, at the very beginning, you said there's places of public accommodations, then there's government buildings. Is that right? So what if a convention center is owned by the county, the city, or the state? Does the ADA cover them on two different instances under two different categories?
It could. One thing I'm finding in a lot of my cases is the concept of sovereign immunity.
Okay.
So a lot of states have said that they don't need to abide by the ADA because they're sovereign, that they haven't agreed to abide by the ADA. So there's a whole line of cases now talking about whether a state entity, for instance, has to accommodate, or whether they can say, well, we're immune from the ADA. And some, yeah.
People are getting away from just being civil to each other.
Yeah.
And
I'm suing the New Mexico bar examiners because they didn't accommodate for a bar exam. And their argument is, well, we never agreed to abide by the ADA, and we have this sovereign immunity for being a state, and so we don't have to abide by the ADA.
wow. And that was just for accessibility to take the exam? Oh, okay. That's interesting.
Yeah. I think basically what's happening as more and more rights are being recognized, more and more defenses are coming up. People are being creative and finding ways to get around the requirements.
Wow. Okay. That just blows my mind.
Yeah.
Yeah.
I mean, you would think that everybody, especially since Title II covers state entities, but the state has to agree. There are some other exceptions, and it's kind of a complicated legal issue. I mean, sometimes they can't use sovereign immunity. But it's just interesting to see all these defenses that are popping up.
Wow. That's really crazy. Now, okay, I asked about employers and guests at ticketed people at an event, but what about the vendors? If you feed the vendors that you've hired to work that event, like your meeting planning staff or your audiovisual staff or your speakers that you're paying to come speak, if you've agreed to feed them, that would fall under the ADA as well. Is that correct or no?
If you're providing food to other people, if that's what you're doing, you're providing food as a service to people, then you are a public accommodation.
Okay.
But if you've just hired, say, a private contractor to come and do work for you, let's say, and feeding is not typically part of what you do, but you just say, okay, as part of your speaking engagement, I'm going to give you lunch, but I'm not giving lunch to the general public. You may not have to.
Okay. All right. So but if you're feeding everybody else at the convention and you're going to also feed that person, then yes. Yeah. Okay. That makes sense. Because if I'm a contractor being hired to come speak at internally at a conference, and you typically let everybody go eat on their own, at a lunch break or whatever, then you don't have to do that. That makes sense. What if people are not U.S. citizens? Does the ADA apply to them if they're attending a conference?
Yes. Yeah. It applies to the place of public accommodation, not the people who come into it. It applies to
okay.
Yeah.
That's a really good, determining thing as well for people to understand. It's like you've rented this place of public accommodation. You're allowing anybody to come in, and it does. So, all right, that's a really good point. Okay.
Yeah, I represented a woman who came from the United Kingdom and sued a resort. And so they had to follow the ADA in regards to her as well, even though she wasn't a U.S. citizen. But because it was a park, it was a place of public accommodation.
Right.
They had to accommodate her just as they would an American citizen.
Okay. That's really important to understand, too, when you've got people from all over the world coming to your conference in the United States. Yeah. And especially if it's open. So what do you wish that people knew about what you do?
I wish people knew that there still needs to be a lot of education out there, that we've come a long way, but we still have a long way to go. And the reason I do it is basically because of my son, because again, when he was diagnosed, there weren't resources. The laws weren't favorable. So that's really given me the passion to try to change things, make a difference, and educate. I think education is huge. I think the more people understand that food allergies aren't just a rash, that you could actually die from food allergy. I think then you're going to get more compassion if you have more understanding and more education.
And what kind of education do you want to see happen? And to whom or with whom?
Well, so for instance, daycares, to understand how to accommodate children. I actually co-wrote a book about a manual for daycares. But just sort of the general public. So a lot of times if you see articles about food allergies and you look at the comments, in fact, years ago, I went to a show with Stephen Colbert, the Colbert Report, and he had an audience question and answer. And so I said, I'm here advocating for food allergies. What do you think about food allergies? And he said he thought it was, and excuse my word, the pussification of the American public.
Oh my gosh.
Yeah.
Wow.
So there's this attitude that we're just asking for special treatment. We're just doing this to get attention, that we're making our children wimpy and not strong. They don't understand it's a medical condition. It's just like any other medical condition. And it's a medical condition that can kill. So when we say we have to avoid certain things, we're not doing it for attention. I'm not doing it to make my kid special or worse. I'm doing it because it's going to save his life. And that, I think, is the attitude that we have to combat, because I think people think it's
not that I dislike cucumbers, because I really do dislike cucumbers, but it's your kid's going to die from eating a peanut, or wow, that really blows my mind.
Yeah.
I mean, and I know that there's a lot of, our friend Leanne has posted a lot of things of different things that have been said on TV and on shows about allergy and jokes being made. And it's just, it really does need to change. I agree with you.
Yeah.
Well, I was just thinking, we talk about the undue burden, right? It has to be an undue burden to accommodate them. But I'm like, think about the burden that people with food allergies and celiac disease have to go through, or people who utilize wheelchairs or have canes or visually impaired. The burden they have to, I'm going to say, get along in daily society when nothing is labeled or there's not a curb cut or such. I'm like, put yourself in their feet, right?
Yeah, and I think maybe a lot of the frustration comes because you're asking other people to alter their behavior. So not just the restaurant, but like in schools. So in Michigan, there was a school that had a peanut ban. And a mother who had a child who didn't have a peanut allergy sued and said, I have a constitutional right to give my child peanut butter in school. And the court said, no, you don't have a constitutional right. She said, well, I have a right to property, and my kid can have whatever property. No, you don't. You also don't have standing because your child isn't affected by the ADA, doesn't have a disability. But I think that the sentiment was sort of, well, you're making me alter something for you. I have to now not bring peanut butter into school or not bring cupcakes into school. And so I think that might be where some of the pushback comes in. That with the ramp, the people around you aren't making the ramp. But sometimes people with food allergies, I'm telling you, you have to change your behavior. And that's, again, with the education, if you understand why they're asking you that,
right?
Why, and that it's not to impose their will on you or to make your life miserable or to deprive you of your constitutional right to peanut butter. It's to keep somebody safe.
Right. Yeah. There was years ago, I planned an event, or I managed the food and beverage for an event and did all the labeling, worked with the chef. And we had one woman who was allergic to apples at that event. And we put a statement. I talked to the organizers. I said, can we just ban apples from the meeting space? And she was so allergic to it that she had a reaction from eating a banana that an apple was in the day before. The bowl. Yeah. And so we removed all apples except for iPhones and Macintoshes and all of that stuff from our meeting space. And we put out a message about it on the communications to the convention attendees and things. And the woman is extremely grateful for what we did, because it was hanging out with her peers for 2.5 days and learning and such. But one woman came up to me at one of the receptions and just chewed me out about it. And she's like, well, we're in this hotel. We were in a Great Wolf Lodge. We were in this hotel. There's got to be applesauce all over this hotel because these little kids eat applesauce and da-da-da-da. And how does she have the right? I'm like, we're not asking the hotel to remove the apples we're asking it for the meeting space. That's all we're asked for 2.5 days. Right. And she's like, well, how does she go to the grocery store? I'm like, I don't know. And I don't care. It's not our business. Right. It's just for 2.5 days. And the chef was great. I mean, he was radioed down to the kitchen. Okay, send me a screenshot of the ingredients of this sauce. And if it had apple cider vinegar in it, we removed. He's like, we're changing the sauce. Right. I mean, I think majority of chefs are willing to do that, but that woman really was perturbed by it, the whole thing.
Yeah. Or the parent who says, my kid will only eat peanut butter, so they have to have a peanut butter sandwich. And to which I say, well, do they eat peanut butter at Thanksgiving? So is it true that they can only eat peanut butter?
Right. Yeah. And you fed your kid poorly if he's in 2nd or 3rd grade and that's all he eats, right? Yeah, exactly.
But okay, it's the same sentiment. You're telling me what I can do.
Right.
They don't understand the reason behind it.
Right. Exactly. And I think it's explaining the reasonings behind it, so that we don't die. I don't want anybody to die on my watch. Okay. So final question. What does a safe, sustainable, and inclusive food and beverage experience look like to you?
It looks like providing a meal that everybody feels included, everybody feels safe. I mean, we talked about how restaurants may not have to accommodate for food allergies in terms of changing their menu. But I mean, for instance, the story I told you about my son going to Zero, it meant the world to him. I mean, to see his face light up and say, I can eat a dessert, I don't have to worry. Mm-hmm. That was the best feeling in the world, because he finally felt included. He finally felt like one of the gang. And whatever you can do to make people feel like they're included and that they're worthy, I think goes a long way.
I do too. And that's a great way to look at it, because you're going to go back to that restaurant. You're going to go and like you said, it's not just him. It's you and his aunt and everyone else that's going to eat with him and all of his friends. Yeah.
Sure.
Yeah. Well, Laurel, thank you so much. I really appreciate it. Everybody, we get Laurel Francoeur, and I've been talking about ensuring equal access, about how ADA and food allergy or food and beverage at events applies to each other. You can reach her, Laurel. I'm putting your website up here at thefrancoeurlaw.com. And reach out to her. You've got a wealth of information. 22 years you've been doing this?
Yeah, a long time. Yeah.
Do my math correctly. Yeah. And how's your
parents who are starting out? It does get easier. The older your children get, the challenges change, but it does get easier.
And how old is your son now?
23.
And how's he doing?
He's doing well. Yeah.
Yeah.
He knows how to navigate restaurants and things. Yeah. It's just been his life. So, and it's made him a more compassionate person, I think, and more understanding. So there are upsides to having food allergies.
I so agree. And somebody just posted on here, thank you, so insightful. So
you're welcome.
Thank you so much for being here. And until next time, everyone, stay safe and eat well. See you next week, everybody. Thanks for listening to the Eating at a Meeting podcast, where every meal matters. I'm Tracy Stuckrath, your food and beverage inclusion expert.
Call me and let's get started right now on creating safe and inclusive food and beverage experiences for your customers, your employees, and your communities. Share the podcast with your friends and colleagues at our Eating at a Meeting Facebook page and on all podcast platforms. To learn more about me and receive valuable information, go to tracystuckrath.com. And if you'd like more information on how to feed engagement, nourish inclusion, and bolster your bottom line, then visit eatingatameeting.com.